Section 149 IPC incorporates the principle of vicarious liability in criminal law. Where an offence is committed by any member of an unlawful assembly, that member is liable, that member is punishable under the general law of criminal jurisprudence. But what about other members? Other members who are not at all involved in the commission of this offence. Under the general law of criminal jurisprudence, they are not liable, they are not responsible. But Section 149 declares that every other member of an unlawful assembly will be held guilty of this offence which is committed by one member of that unlawful assembly. The law enacted by Section 149 shall be applicable only when the offence in question falls in one or the other of the two categories specified in this section. First, if the offence is committed in prosecution of the common object of the assembly. Second, if the offence is such as other members of the assembly knew likely to be committed in prosecution of the object. Section 149 shall be applicable only if the offence in question falls under any one of these two categories, not otherwise. We will now see the law of Section 149 as laid down by the Supreme Court. We will be discussing two judgments. Here is the first one, Mijaji versus State of UP 1959. There are two parts of Section 149. Under the first part, the offence must be one which is committed with a view to accomplish the common object. For the case to fall under the first part, the offence must be connected immediately with the common object. And this is the second part. Even if the offence committed is not in direct prosecution of the common object, it may yet fall under Section 149 if the offence was such as the members knew was likely to be committed. It is the knowledge of the members that matters. If the members had the knowledge that this particular offence was likely to be committed in prosecution of the common object, then it will be covered by the second part of Section 149. The expression no does not mean a mere possibility, such as might or might not happen. It must be something more than that. The court gave two examples in this case where the second part can apply. This is the first example. It is a matter of common knowledge. We are talking of knowledge here. The court says it's a matter of common knowledge that when in a village a body of heavily armed men set out to take a woman by force, someone is likely to be killed, and all the members of the unlawful assembly must be aware of that likelihood and would be guilty under the second part of Section 149. In such a situation, where a body of heavily armed men set out to take a woman by force, if a murder takes place, then it can be safely said that all the members of that unlawful assembly knew the likelihood of this offence and they would all be held guilty of the offence under the second part of Section 149, even though the murder might have been effected only by one member or by a group of members for that matter. Second example. If a body of persons go armed to take forcible possession of land, it would be equally right to say that they have the knowledge that murder is likely to be committed if the circumstances as to the weapons carried and other conduct of the members of the unlawful assembly clearly point to such knowledge on the part of them all. In Chandra Bihari Gautam versus State of Bihar in 2002, the Supreme Court said that section 149 is an exception to criminal law. Here, a person can be convicted and sentenced for his vicarious liability only on proof of his being a member of the unlawful assembly, sharing the common object, notwithstanding as to whether he had actually participated in the commission of the crime or not. Even if he had not actually participated in the commission of the crime, he can be convicted and sentenced simply on the ground that he was a member of this unlawful assembly. A person is a member of the unlawful assembly only when he shares the common object. So when we say he was a member of the unlawful assembly, it is clear that he shared the common object too. And common object does not require prior consent and common meeting of minds before the attack. The requirement here is not prior consent or common intention. The requirement is common object. An unlawful common object or an unlawful object can develop after the accused assembled. So it is not necessary that they had an unlawful object to begin with. This is what explanation to section 141 also says. An unlawful object can develop subsequently also. This is another important statement of law made by the Supreme Court in this case. Mere presence of the accused is not sufficient to hold him guilty. Mere presence where? Mere presence in the assembly. I had emphasized this point earlier also. The presence of a person in the assembly does not hold him guilty. He becomes guilty only when he is a member of that assembly. And we know what is the requirement of being a member. Section 142 clearly lays down two requirements. The Supreme Court goes on to say that prosecution has to establish that this person was not a mere bystander, but in fact he was sharing the common object. There may not be a common object in a sudden fight, but in a planned attack on the victim, presence of the common object amongst the person forming the unlawful assembly can be inferred. This is an answer to the question as to how do we know whether a common object was there or not. And the answer is that if it is a sudden fight, we can say that there may not be a common object. But if it is a planned attack, then presence of the common object can be readily inferred. Section 149 has two parts. First part deals with commission of an offence by a member of an unlawful assembly in prosecution of the common object of the assembly. And second part deals with the liability of the members of the unlawful assembly who knew that an offence was likely to be committed in prosecution of the object for which they had assembled. So here knowledge is required. Knowledge of the consequential action in furtherance of the initial common object is sufficient to attract the applicability of section 149 for holding members of the unlawful assembly guilty for commission of the offence by any member. Commission of the offence by any member. All are held guilty. Now let's find out the difference between the provisions of section 34 and the provisions of section 149. This is a common question and we should be very clear about the difference between these two provisions. In section 34, the term used is common intention, and that term is not defined anywhere in IPC. Whereas in section 149 read with 141, the term used is common object, and the common object is defined in section 141. 5 common objects are defined there. Any one or more of these common objects will be sufficient to attract the provisions of section 149. Common intention being the requirement of section 34 requires prior meeting of mind and unity of intention and an overt act in furtherance of the common intention. On the other hand, common object may be formed without prior meeting of mind. So no prior meeting of mind is required for common object. Section 149 applies when the object of the members is common, even though intention of the participants is different. So intention is not material for applicability of section 149. For invoking section 34, it is sufficient that 2 or more persons were involved, but for invoking 149, there has to be a minimum number of 5 members. The crucial factor for invoking section 34 is participation of all the members, while there is no need of active participation of all persons in section 149. Even if the offence is committed by one member, all other members of the assembly will be held responsible for the same and are liable to be punished for the same. Another important question which we are now going to answer is this. Does section 149 IPC create a separate offence? Does it create a new offence? There has been some controversy as to its answer. Some books say that section 149 creates a new offence. We now have an authoritative answer from the Supreme Court in Vinubhai Patel versus Rajivbhai Patel in 2018. The answer is very emphatic, very clear, and this is what the Supreme Court has said in this case. Section 149 IPC does not create a separate offence. It only declares the vicarious liability of all the members of an unlawful assembly in certain circumstances.